Bismillah ar-Rahman ar-Rahim. Coming back to the same chapter we had, we have to finish it today. The last section of chapter 1, we will focus on definition. How can we define commercial law? And we would see the difference between civil and commercial law. And at the end of this chapter, we have to look at the features or characteristics of commercial law. Firstly, we have to define commercial law. We find it difficult, mostly, to have one definition for commercial law or for business law, because we can see it from different angles. Some scholars can see commercial law by different meanings. So to have one complete, comprehensive definition is something impossible. And at the same time, commercial law is vague. It's not clear. It's unclear. We cannot know sometimes what's the content. It depends on each country. In Palestine, in Egypt, in Saudi Arabia, in America, they have different content. What does it include? We're looking at the provisions of commercial law. It's not the same all the time. And even some countries do not have commercial law. They only have civil law. And commercial law is included within the content, within the subject of civil law. This is why we find it most likely not easy to have one definition. But despite this, we can define commercial law. We can define it. We can use our own way. And we can look at some scholars how they define it. Looking at this definition, for example, here, it says that commercial law is a body. This body of legal rules, which can be applied or applicable, which we can apply to commerce, commercial transactions, and organizes merchants' profession. The main difference between civil and commercial law, that commercial law is applicable to two main things. Number one, transactions, commercial transactions. Number two, it's merchant's profession. Any transaction you make as a commercial transaction, selling, buying, exchange, insurance, rent, these contracts as commercial contracts and transactions are included under commercial law. At the same time, look at merchant's profession. How can I become a merchant? How can I organize my job? Legally, merchants have to use some requirements, some conditions by law. If you would like to become a merchant, you have to follow the conditions made by the government, like spending time in the market, working in business. And you have to follow up, like having some special notes. You have to take them into considerations. You have to register your name at the Chamber of Commerce. You have to register your name at the registration office, which belongs to the Minister of Economics or the Minister of Commerce or Trade. Now, all this can be organized by commercial law. So you can understand from the beginning what we need exactly, how can we make it, what steps we can take in order to be merchants working in the market. Is that fine? So, again, it's here, commercial law focuses on business actions and behaviors. And business, you have been studying as students of business administration. What does it mean to you, business? How can we understand business? What's business? What does it mean? Okay, anyone else? How many of you are business administration students? All of you, or most of you? Most of you. So what's business? What does it mean? No? Well, anyway, in a few minutes' time, in the next two slides, I will explain it to you. We have to look at business, the meaning of business, because business law or commercial law focuses on business and commercial transactions. We have to know the difference between business and commerce. So business transactions and certain category of people, merchants. Looking at two main points, two main things. Commercial law is the branch of private law. It's not public. And we said from the beginning the difference of private and public law. They are not the same. Public law is concerned with a relationship in which the state can be a party. But when it comes to private law, we have two parties. One of them is an individual person, and the second one is the same. The state will not intervene. The state has no business here, cannot intervene in this contact and this relationship. This is a private law. And so commercial law is a branch of private law which applies to business transactions. That's number one. Number two, it's certain category of people, which is merchants. So if we have any contact or any dispute, any conflict between merchants, then we have to apply commercial law. And if we have any conflict concerning business transaction, then we have to apply commercial law. If we have any conflict between two civilians, students, and another person in a society, then we can apply civil law. Civil law. Civil law is the main source for commercial law. Civil law is applicable for all people. If I have a conflict with someone else in this society, as a teacher, as a citizen in this society, then civil law is applicable, not commercial law. Is that okay? Anyone can read this for me? And so we have business dealings. Business dealings including exchange of goods and services, buying things, selling others, getting money, transaction, transferring money and goods. And the most common type of business transaction is sale. Sale. But how many times a week, how many times per day you make a contract? How many times do you buy? When you buy something to eat from the canteen, you can buy coffee. That's sale contract. How many times you buy food, you buy drink, you buy clothes? That sale contract is the most common thing we face in our life. So we have to study sale. Sale of goods. This will be chapter 4. We will study that chapter 4. Anyway, nowadays in general, we find commercial law is concerned with any business activity, with any transaction which has an economic value. Any transaction, think about any transaction. صفقة or معاملة, which has economic values, which has a profit, making money. In this case, we can apply commercial law. We're going to have some examples later on. Even people who like people who are involved in mining activities, looking for coal, oil, gas, those people, gold, this kind of business is included under the ceiling of commercial law. So we can apply commercial law. So anything is connected with economic values, or anything can transmit economic value, is subjected to commercial law. We can see at the overall that commercial law has evolved from civil law and has evolved from private law. So commercial law has evolved from private law. So you find general principles, the main principles in private law are applicable to commercial law. So if we miss any point in commercial law, we have to go back and look for it in the private law. Because commercial law is not comprehensible. It's not fully completed. Sometimes we have some conflicts in which we cannot find a solution. We cannot find a term or rule. Then in this situation, we have to go back to the private law. Because we have the same general principles. نفس القواعد. Commercial law and in private law. The same here, where the essence of general principles, transactions of individuals. But despite this, despite the same idea, the same connection between the two sides, commercial and private law, we find there is unique approach for commercial law, in which we have to find a new branch, which is commercial law, which has to be independent, has to be standing alongside other branches of law because of the quality of activities. Because the quality we have in commercial life, it's not the same like civil life. Everything is fast and quick. We have the trust, we have the speed, and at the same time the privacy of profession. Because those people that are minority in this society, or in other societies, a group of people called traders or merchants, they have their own way of life. They are not working within the overall community, but they have their own way, traditions and customs. Though, in this case here, this time, those people have to have their own branch of law because of the privacy of their own profession. And at the same time, we have the swift transaction between the traders and haste process of business and commerce. Haste, quick, fast. Haste process of business and commerce. Not like in civil life. In civil life, you can buy, you can sell. I can make a transaction today. I can delay it. I can make it tomorrow, maybe next week. If I would like to buy a laptop, I can do it today, or I can leave it till next week. I'm not in a hurry. But when it comes to business activities, we can't wait. We make a transaction so quickly, and the money flow between merchants and customers, in which you have to pay the money in order for the merchants to take that money and pay for someone else. We have a circle of debtor and creditors. Debtor and creditor. Madin uda'an. So I pay the money for you, and you take it, and you pay for someone else, and this circle go on. So we cannot stop business, and this circle has to be so quick, so fast. Everything is going on a speed, and this speed has to be consistent. We cannot wait. We cannot delay business. This is the difference between commercial law and civil law. Can you hear me? Are you okay then? Good. Some scholars said that commercial law can be often to be considered as a branch of civil law, not from private law, but from civil law. And even sometimes in some places like United Arab Emirates, they do not have commercial law. There is no commercial law. They have only civil law. And that civil law includes some aspects of commercial activities. So in this situation, if we have conflict between merchants or concerning business activity, then we have to go back to the civil law. Civil law. Like here, branch of civil law, it is. Some countries, and even some places like in Palestine here, if we cannot find a solution, if we cannot find a way to solve any problem of commercial activities in commercial law, we can go back to civil law. Civil law is comprehensive, and when it says that even in each state, I cannot say that all states in United Arab Emirates don't have that commercial law, but at least in some of them, they have only civil law. And in civil law, it includes all the rules we need to look at commercial activities. So it's comprehensive, inclusive, including all what we need, all what we should. Like, for example, looking at the contract. How can we establish a contract? How can we have an agency? The same principles. Contract is the same in civil and in commercial law. We have to have acceptance and offer. Offer and acceptance. Intention, consideration, the value. This can be in civil and it can be in commercial. The same thing. Will not be different. At the same time, like looking at agency. Agency. In commercial law and in civil law, it's the same meaning. Will not much difference. Will not make much difference. The only difference we find here is the speed and the trust and the mechanism and the process, how we make it, how long it would take, and how can we advance it, how can we speed up the whole process in order not to delay the business. See that many countries today have adopted civil codes. When we say codes here means acts, it means law. Codes, yeah, تشريع. It means here acts. Some countries have adopted civil codes only, and there is no commercial codes. In this situation, we can go back to the civil codes to look at them, what they have, how can we use them, how can we apply them in commercial life. This definition we have now, second, third definition of commercial law says, what does it say? Anyone can read it? It says here commercial law, it is the same business law. It's a body of rules. And this body of law governs business, commerce, and consumer transactions. Again, looking at the transactions. What kind of transactions? Commercial transactions. And it looks at business and commerce. Civil law does not look at business or commerce. Does not have any intention or any concern about business or commerce. Civil law look at the civilian relationships. Commercial law looks at business and commerce. Let's have a look now at business. What does it mean? What does it mean, business? How can we look at it? Again, I did ask the question a few minutes ago, but none of you has answered, except one. Anyone else? Business. It has many meanings. One of them is it's an entity. Business, it can be an entity, a place, an organization, an institute, company, supermarket, something physical we can see, we can deal with. So, business in economics is a legally recognized organizational entity. It's an entity which can be sometimes called firm. Firm, it means company. Company. And this business entity designed for one thing, for main goal. It was designed for selling goods and or services to consumers or other businesses in order to make a profit. So the whole intention is to make money, to make a profit. Make a money. Business, it's not like non-profit. We have a profit and non-profit NGOs. We're going to look at them. We're going to have to see all these entities, how they function, how they act, what kind of law we can apply. So those non-governmental NGOs, organizations, they have one thing in common. If they are business entities, they have the intention to make a profit, to make money, to gain some money by selling goods or services. You can sell service like teaching, like security, cleaning, advice, research. Those are services. You sell them for money, for something else. And you can sell goods. It's not only one thing. But at the end of the day, the intention is to make profit, to make money. This is something we can use to distinguish between civil and commercial law. In civil law, civil life, we don't have the intention to make money. Even if we make money, as a civilian, I can make money. But this is not a profit. It's a gain. It's income. It's a reward. In business, it's called profit. And this profit yeah, we can take it for the risk. Because I invest money because I would like to make profit. So you take the risk here. As you can see in this point, we have to distinguish between capitalism and socialism. And I guess you know the difference between them, do you? So what's capitalism? You want to say it? Capitalism. Anyone? Come on. It's not difficult for you. I don't want you to translate it. I want you to explain it. The concept. Capitalism. Socialism. Okay, this is the basic definition or difference between them, which is fine. It's acceptable. Looking at the capitalistic system here, economies, most businesses are owned by private firms, by individuals. Most businesses are privately owned. People, individuals in the society, they can act, they can buy, they can sell, they can make transactions on a daily basis, and you have the freedom to compete. You can compete. Within the same community, you find millions of traders, millions of merchants or companies. You find thousands of them. It depends on the size of this society. Everyone is competing to make more money. Everyone wants to make profit. And you have the freedom to do so. The state will not interfere. The state would make the guideline. The state would give you a guideline, what to do exactly, how to make it. In case if you breach the law, what would happen? But the state will not intervene in your business. It's your life. Yeah. Profit, growing personal wealth of their owners. The owners of business aim to generate financial return in exchange for their work and their acceptance of risk. You take the risk when you invest the money, but this risk, you take it because you would like to make a profit. And this gain is justified. It is justified. But we have some exceptions here. The exception is non-profit. Non-profit organizations which are owned by here, cooperative, call them cooperative businesses, own or and government institutions. Those non-profit organizations do not make a profit, do not make money. We cannot use commercial law. We have to apply civil law. If we have to apply civil law. On the other side, looking at the socialistic system. Socialistic system, most businesses are owned by the government. Most businesses owned by the government, not by individuals. This led some scholars to think and to say, if there is no individual merchants and no competition in the market, and the state owns everything, in this case, there is no point to have commercial law. Because commercial law is applicable to merchants' profession, مهنة التاجر, and commercial transactions. In this case, we don't have merchants. We have only the state, and the state owns most businesses. We can respond to this saying, well, even though the state owns most properties and most businesses, still there are some individuals in the society, some of them working in business, even if they are at the small scale, not investing too much money, small merchants, small size businesses. And we still have business, we still have transactions. In this situation, that there is a need to use commercial law. So we cannot ignore it. We cannot marginalize commercial law. I would look now at the meaning of business, language, etymology. The etymology of business, the meaning in language, علم الكلام. What does it mean in language, business? It's the status of being busy, engaged, doing some business, some activities, making money. Here, busy either as individual or as a society. This is the status of being busy. That's the language. When it comes to the term, the meaning in commercial law, business has more than one meaning. Business has many meanings. Number one, which we just had now, a few minutes ago, that business, as was mentioned above, is a company. It's an entity. It's an organization. I can say, well, I have my business, which I mean my company. I would say that I have my business, which I mean it's a supermarket. It's a store. This is number one. Number two, business can refer to what? Certain market sector. In the market, we have many sectors. In the market, there are many sectors. Some of them are clothes, food, electronics, drink, other sectors. We have many sectors in the market. Now, each sector can be called a business. Like the food industry, it's called a business. And so on and so forth. Number three, we have the broadest meaning, in which most people use. When you stop someone in the street and you ask him, what do you do? And he says or she says, well, I'm doing business. This would bring to your mind many answers. Would it bring something in general, that business includes everything? Well, just he or she is making money. It's the broadest meaning, including all activities, everything. This is the general perspective by people, community, of suppliers of goods and services. Broadest meaning to include all activities. Selling and buying, sector, company, place, entity, everything included under this broadest meaning. أوسع معنى, includes all activities. In any way, even though we have three main definitions of business, we cannot define it. It's still vague. Still, we can add, we can delete, we can combine. Still, that we cannot have an exact definition of commercial law. It's not easy. As I said again, it depends on how we think about it, how we plan it, and how we act in a society. And it depends on each country, how they think and they look at commercial activities. Then they can define commercial law. And they can define business as a main element of commercial law. Okay? Second point is commerce. What does it mean, commerce? I guess you have been studying the meaning of commerce and business, and it's not something new for you. Good. So, I think business is a wider conception than commerce. Commerce is only one division, one slide, one section. Commerce, it's a trade. It's not like business. Business includes all activities, but commerce includes only division of a trade or production, which deals with exchange. When you look here, look at the exchange, producer and consumer. And in between, here, this is commerce. In between, if you look at the production line, if you look at the factory, this is not commerce. It's manufacturing. And when you look at the consumer, I can be the consumer. You can be the customer. Then you are not a merchant. You are a civilian. So commercial law, as commerce here, it's only applicable to the steps are made at this time, at this end, in between the production line and the consumer. The exchange. By someone is buying by wholesale, and he or she is selling to someone else, a retailer, and he can sell to the consumer. So this process of exchange is called commerce. It's a shorter process. This is a traditional meaning. But nowadays, some scholars say, well, Well, if we cannot include the production line within the commercial activities, this is not fair. Because the factory, the producer, can make more money than a merchant. What do you think? The factory, the production line, can make more money than any merchant in the market. If you manufacture 500 PCs per month and you sell them to 3-4 merchants, of course you're going to make money. If you have a big factory, production line, and you make money, then in this case you have something called an economic value. You make a profit. There is a profit. So it's not fair to apply commercial law only on merchants and not to apply it on the production process. And the new meaning, the new conception of commercial law says that we have to expand commercial law to be applicable to all economic activities. Everything has an economic value. Anything with an economic value, it has to be considered as part of commercial law. Like even here, not the consumer, but anything beyond this, the production line, the exchange, all of this can be considered as part of commercial law. Because as you can see here, it comprises the trading something with economic value, such as goods, services, information, money. Now, people think that trade or commerce is consistent of selling and buying goods. It's not only. You can sell service. You can sell information. You can exchange money. You can exchange information. You can share information. Those are services. Can be included under this title. There's something else called commercialization. هي عملية what's commerce؟ تجارة. Commercialization عملية التجارة consists of what? The process. It is a process, and this is a process of transforming something into product, transforming raw materials to product, service or activities which one may then use in commerce. This commercialization process in which we can benefit using some materials and transferring them to become a product, goods, then we can sell until we get to the stage of reaching the customer, the consumer. No, this is not the production only, but this is the commercialization, عملية التجارة, from buying from one place, from the factory, until we reach the consumer. In between, there is something called commercialization. Yes. Okay. Any question? How do you find it? A bit difficult? Somehow? It's okay. Look at the concept of commercial law, the modern concept of commercial law. The modern concept of commercial law. How can we look at it today? How can we see commercial law? We have to look at the provisions. What does it include? To be able to understand anything in your life, then you have to look at the content. What does it include? We have to look at the provisions. What commercial law looks at. We have to look at the economic side. Some scholars nowadays say commercial law is the economic law. It's the law of economics, because it's including all activities which not supposed to be at the beginning as commercial activities. Like, for example, manufacturing. This process of manufacturing, which is, we call it the production line, It was not included in the past under commerce, but today it is commerce. It's in the commercialization process. The production line. This concept would cover all topics, all subjects, all activities involving any economic activities. Anything connected with money, with gaining money, making profit, anything connected with this is considered under the concept of commercialization, business, and then it can be subjected to commercial law. Commercial law. Thing is, if you look at commercial law, it has constant evolution, has development, does not stop. Not like other pieces of law. Civil law, a little bit slow. We can modify, and we can amend all the branches of law we have, but the quickest, the most advanced branch of law is commercial law. And this is because we have a new industry. We have a new situation, technology in the world. If you look here, we have a progress in the field of industry, trade, production, market, tools. And all of these technical steps and all of these developments would have to have a new legal versions. We have to have new rules to respond to the needs of the market. We have a new technology nowadays, which we did not have in the past. This technology we have nowadays did not exist a long time ago. Look at the computer, the TV, the cars. They did not exist a long time ago. Look at the contracts we have today. Look at the market. Look at the speed. People in the past used to have oral communication, buying and selling. But nowadays, you can use the internet, online, to buy and sell, what we call e-commerce. This would need advanced verses of law, which we cannot use the old system, the traditional system. We have to adopt something new. Commercial law evolves more rapidly than any other branch of law. If we amend criminal law every 4, 5 years or 10 years, commercial law we have to amend it every few months. It depends what we have in the society. How can we look at it? Because we have a new industry, new contracts. Then we have to look at the law and how can we use it and how we can adapt it to respond to the need in the market. Like, for example, we have some new contracts. These contracts did not exist a long time ago. For example, in France, in recent years, they have contracts between, they call them sale through agency. Those contracts did not exist in the past. We just had them in the past few years. Like car factory with a distributor, oil companies. We have many oil companies. Like, for example, Shell. Shell is one of the biggest companies in the world. One of the biggest oil companies in the world. Shell. And this company has many distributors, موزعين. Those distributors take the oil from that company and distribute it to the customers. Now, we have something that's called the sale through agency. Sale through agency, يعني بيع بالوكالة. بيع بالوكالة. That using this agency بالنيابة on behalf of the principal. On behalf of the principal. Such contracts were not there in the past. 100 years ago, 200 years ago, we did not have something like this. These are new contracts. But if we have something like this, we might have a conflict between the agent and the principal, اللي هو الموكل. So how can we solve it? If there is no rule, if there is no verses in law, then we have to amend the law to be suitable, to be appropriate, so we can use it in such situations. So the concept here, even the same thing here, working in mines, coal, iron, oil, this can consider to be business activities. Because companies who work in mining, digging in the ground, getting gold, materials, oil, they get money. They get lots of money. And if we do not apply commercial law, this is not fair. We have to apply commercial law because in this situation here, those people making a profit. And it's an economic value. Economic value. So, can you read this here? In these contexts, in these situations, you find that context of commercial law was developed from civil law. Like in this situation here, we could not find a solution in the past. We went to civil law. It's the same idea. In civil law, we applied it to commercial law. Development came from civil to commercial law. But this comes more specific in commercial law. To be more specific, in which that merchants only can use such rules. Merchant. And despite the fact that in life, civilian life, we can use the same law, which is civil law. But the procedures are not the same. In commercial law, it should be fast and quick and based merely on the trust and the confidence. We still have, I think, 5 slides to finish with in this chapter. And we look at the distinction. How do you find it up to now? Kind of difficult or easy? I think next chapter, chapter 2, will be more easy. Agency will be so easy. One of the easiest chapter we look at next one, which is agency. Now, as an introduction for commercial law, I know that we have many points and complication and civil and commercial and the interaction between them and how we can apply. You need something practical, which will be next time. Next lecture, we will look mainly at agency and how can we make agency. Principal, muwakkil, agent, wakil, customer. How can build the agency? How can it work? Why do we need it? That's an easy one, easy point, an easy chapter. We'll look at it next time. But we have to complete now what we have here, looking at the distinction between civil and commercial law. Anyone can tell me what's the difference between them? Are they the same? Or do we have any difference between civil and commercial law? Are they the same? They can be sometimes. Some places, in some countries, civil and commercial law are the same. But sometimes they are not. We find some differences between the two branches of law, despite the fact that commercial law has come from civil law, and despite the connection and the strong relation between them, we find some differences. And these differences mainly in speed and trust. Speed and trust. But before this, we look at the provisions, commercial law, business and commerce. The content of commercial law is business, commerce. But those do not exist in civil life. Do we have business in our life as civilians? No. We're not making business. We're just acting in our life normally, doing our best to survive, to live a decent life. It's not business. The business is connected only with merchants, people in the market, those special category. So, civil law is connected with civilians, their relationship in this society. And despite this, we find that many contracts in commercial law have come from civilian life, have created special provisions, civilian life, such as, for example, commercial contracts. Contract is the same thing. Contract in civil law, commercial law, it has the same meaning, same conditions. Commercial papers, bankruptcy, agency, and so on and so forth. The same thing. But despite this, we have main difference between them. Speed and the trust. And the speed and the trust connected only with commercial law. Civilian life, civil law, a little bit slow, can delay the business, take time, and spend money. We have a trust in civilian life, but this trust is not as strong, is not as the amount of trust we need in commercial life. It's not the same thing. Can you read it?
Scholars recognize that speed and trust is conducting business effectively. Important in commerce, recognized in commercial law.
See, speed and trust, they are important in commerce, but they are recognized in commercial law. So commerce is based on the speed and the trust. We will look at them point after point, the meaning, we have to explain them, but these two main elements exist in commercial law. They are. If we can find them in commercial activities, we have to adopt them in commercial life, commercial law. We have to, because to be able to respond to that need, speed, we have how many transactions we make per day, per minute. Then we have to have law, and this law have to be suitable, appropriate for such situation. Go on. Like, well, if you can bring them, look at them next time, it will be good. Look at the speed and the trust. Speed and the trust, the main two elements which we can distinguish between civil and commercial life and civil and commercial law. The speed and the trust at the same time, two main features for commercial law as we will look at in the next few minutes. Speed is a fundamental element. Speed is something necessary, something important. In business, you cannot work without the speed. In civilian life, it doesn't make difference. I can make my transaction today, or I can make it in a few days' time, a few weeks' time. But when it comes to business, merchants need to make their own transactions on the spot, on time, at the same minute. It doesn't take even sometimes a few seconds. Looking at big supermarkets and big companies, they make thousands of transactions per day. Thousands. How long each transaction would take? A few seconds. We cannot delay. Sometimes when the electricity is shut, this would delay the business. They would lose money. If you look sometimes at those big companies, if they shut electricity for a few minutes, then they would lose millions of dollars. If the internet is not working for a few minutes or for one day, they would lose a hell of money as well. So because of the speed and because how many transactions they make, then everything has to be fast. And even law have to respond to this. If the business and the transaction are so quick, we're making many of them, thousands of transactions per day for each company. Now, if we have a conflict with this company and its customer, and between two companies, do we have to go back to the civil law? That will make it difficult for those companies to survive, to be able to make their own way, because if we apply civil law, the civil law would delay the whole business. It would be difficult for me, for you as merchants, to continue. No, we need the money quickly in order to be able to pay this money for a different merchant, for the factory, to buy some goods, to pay the debts. We need this circle of debtor and creditor, paying and buying, to be easy and smooth. So speed is a fundamental element in commerce, and it's needed very much in commercial law. And this has some implications, some consequences in real life. How? Okay, we have speed, so what does it mean? How can we apply it? We can apply it. Like in court, cases like lawsuits, civil lawsuit, takes a few months or few years. But commercial lawsuit, الدعوة القضائية, lawsuit, it takes only a few weeks, a few months maximum. That's if we have a specialized system. In Palestine here, we do not have a specialized system. So both commercial and civil lawsuits are considered by the same judge. That's not fair. It's not good. If we have a specialized system, special courts, special judge, he can or she can look at your case, at your lawsuit in a few days' time, in a few weeks' time. And even in addition to this, we have the freedom of approval. This is an important thing. Freedom. In civil law, if you have your case in the court as a claimant to claim something, you have to prove your point. But you have to follow the system as it says exactly. What are the procedures? What kind of procedures do we need? How can we use them? What kind of a step we can take before the court? If you do not follow the procedural system, the procedural law, then you can lose your case. You have to stick exactly to what the law says. But when it comes to commercial law, you have more freedom. You have more space. Freedom of proof. You can bring the evidence you like. It doesn't have to be written down. The evidence can be oral, can be by writing, can be by the registration book, it can be by some notes, it can be by the bill, by the computer. So you have more freedom, because we do not like to impede يعوق the business. We don't want to impede it. We don't want to delay our business. We want to do our business so quickly, so the law itself has to respond to our needs. Is that okay? Go on, what do you want to ask? That's okay. Second element is trust. Can you imagine business, commercial transactions with no trust? You cannot imagine this. You will not be able to work in the market if you don't have trust. If customers loses faith in you, then you will not be able to work anymore. If you lose your customers, you cannot make business. You're going to close down. Trust is one of the main basic elements which is needed. Trust is needed in civil law and in commercial law. But it's needed more strongly in commercial law. Because commercial law is based on large number of transactions. Large number of transactions on a daily basis, in each minute. And you spend too much money. So trust has to be there. Confidence has to be between the merchants. That's commercial law. What commercial law would do exactly? Would strengthen the credit and the trust. If we have a trust between merchants, between business and the consumers, we have a trust. How can we strengthen, how can we guarantee that I would pay the money and you would pay? I would deliver the goods. How can we guarantee that this business and this transaction will be implemented? By law. So these points here, speed and the trust, are guaranteed by law. Guaranteed by law. So what's happening here is commercial law would strengthen the credit and the trust by two main points. Number one, how can we strengthen is by increasing a creditor's guarantees. ضمانات الدائن بنزيدها. دائن. Creditors. Guarantees. We look at two. Number one, the creditor. Number two, the debtor. We have to increase creditors' guarantees. And at the same time, imposing harsh sanctions, harsh punishment on the failing debtors. Especially if that debtor does not deliver on time. If I supposed to pay the money on time last month and I did not, I could not pay the money. If I was a civilian, I would be given more chance, more time. I'd be given like 1 or 2 weeks, 2 months. It depends on the judge. But when it comes to commercial life, we have harsh sanctions, عقوبات sanction. Sorry, man. On the failing debtor, if you don't pay your money, if you don't pay your debts on time, then you're going to face harsh sanction, harsh punishment. This is kind of guarantee for the trust between. So we can, like, we have a circle, and this circle, between debtor, creditor, debtor, and the creditor, and so on and so forth. One of them has to pay on time. Each one of them would pay on time. If you don't pay the money on time, then the whole circle of business would be delayed. And then we will not have a smooth and easy process of commercialization in the market. So the law can guarantee that if you cannot work in the market, if you cannot pay your debt, then you have to be punished, and then you might be excluded from the market. The same point as you see here, we can look at them in the features or characteristics of commercial law. مزايا. Looking at the characteristics of commercial law, we have 5 features of commercial law, but these features depend on business environment, providing legal tools, and enabling traders to conduct transactions smoothly, simpler than civil law. Simple way, easy way, not like in civil law. So these characteristics, these features are based on the business environment. But at the same time, these same features go for the commercial law. But they come from they come from business, they come from transactions, from commerce. But the same features are applicable to commercial law. Number 1 is making a profit. Can you imagine a business not making a profit? No, it's not intending to make a profit. If you have a business, you might lose, you might win. You may make money, you take the risk. But this risk, you take it for the profit, for the return, for the income. You may make a profit, you may not. At least here, you have to have the intention in your mind, in your heart, that I have my own business because I want to make a profit. But if you do not have intention, then it's not a business. If I open a company, and this company is teaching the children, teaching them for free, is that a business? No, I'm just trying to help people. If I open it because I have the intention to make a business, sell books and articles and stationaries, then it can't be a business. Selling and buying here and having the intention to make a business. In this situation, making a profit is one main feature. If we don't have the intention, it can be like non-profit organization, non-profit company. And then we have no choice to apply commercial law. Then we have to apply civil law. So making profit is feature number 1. Number 2, speed and trust. I guess it's the same what we said just now. I don't have to repeat them again. There's no point just to say the same words. Saying that speed is the main element and it's consistent with the need of merchants, and the law have to guarantee the speed. And the same thing, the trust, the credit. Trust between the merchants and the customers. Trust in business. And the law would guarantee by imposing harsh sanctions on the failing debtor and trying to help creditors to guarantee their money. I've just explained them, and there's no point to go back again to the same point. Last 2 points, last slide here, and this is chapter, which is feature number 4, openness, publicity. Openness, what does it mean for you? What does it mean, publicity, openness? Anyone else? What's your name? Jada. Anyone else? When you say publicity, openness, advertisement, okay. Like, oh yes. Fairness. Can you make business at home and just shut the doors and the windows and not telling people about it? No, everything has to be done publicly. It's not a secret. It's a business. You sell to the customers. You contact them. You open your doors to people. Anyone can see you. You can advertise. Publicity. Your commercial activities must be exposed. Commercial activities must be exposed. واضحة. Easy. Clear. Anyone can see them. Merchants have to take some steps which by law they have to take them. Like for example, if you are a merchant, you have to register your name at the Chamber of Commerce. Is that publicity or not? Yes. Openness. If you are a merchant, you have to register your name as a company, for example, at the company house. The company house. مسجل الشركات. It's called company house. If you have a bankruptcy, this bankruptcy sentence will be published in a newspaper. So everyone in a society can see that. And you will not be able to deceive anyone. You cannot deceive anyone. Your name will be clear in the newspaper. Everyone can look at that, can see it. People will be suspicious about dealing with you in the future because you have committed something wrong. By the way, when it comes to bankruptcy, we have completed chapter. We will look at it in details. Bankruptcy. And again, we have to be obvious, clear. We have to adopt openness, publicity from the beginning, in which our business can be achieve money and profit, and at the same time achieving equity and justice for the market and for the merchant. Last point is goodwill, integrity, حسن النية. You have to have a goodwill. Some scholars say, well, this is like this point, it's not needed to be mentioned here because anyway, this has to be taken into consideration by all means. If you work in business, you have to work with goodwill, with integrity, with good intention, good mind, good heart. Even if we don't mention it, even if we don't talk about it, even if it's not mentioned in the law, goodwill and good intention, something basic, something has to be adopted by all people. I cannot deceive anyone in a society. Like, this is based on the confidence. Deals, transactions, carried out mostly orally. If you work in the market, you can see that merchants deal with each other orally. In some cases, they don't write down anything. There is no evidence. In many cases, merchants pay money and they don't take evidence. Get the goods, they don't take the evidence because they have a trust, they have confidence, they have goodwill. So in this case, if I deny my colleague's right, that's going to be a problem. It means he lost the trust in me. There is no goodwill. It is. I mean, goodwill is connected so much with the trust. It's mean here confidence. Confidence, ثقة between the merchant. It's based on this point here. If I lose trust in you, I will not be able to deal with you anymore. If you deny me my rights, if you're supposed to pay me like $10,000 this month, and you said that you paid them already, and we have no evidence, I mean, there is a mistrust here between the two sides. So we have to look at these points as features of commercial law. And at the same time, these points are the characteristics of business and commerce. Business and commerce. Thank you for your time. And Tuesday, we have the presentation, and we have to go for Chapter 2 agency.